Court warns 2020 NDC presidential candidate John Dramani Mahama it will invoke sanctions against him should he fail to file his witness statement by close of work tomorrow.
The petitioner is again directed to file his witness statement on the matters raised in his petition and other pleadings and his response to the preliminary objections by close of the day on Wednesday, the 27th of January 2021, failing which this court will proceed to invoke the sanctions imposed on this court by the rules of court.
President Akufo-Addo's legal team has hit hard at Mr. Mahama, questioning why his lawyers opted to disobey the highest court of the land.
The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit.
The NDC legal team has fired back. We'll bring you their reaction and find out how many more days the Supreme Court has to deliver judgment.
The 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis.
And Top Story is brought to you by Blackcomb Mineral Water, Vodafone, the future's exciting, ready, and Gasm Cement, the nation builder. My name is Ernest Manu. Tonight, the Supreme Court justices expressed their displeasure at lawyers for 2020 NDC presidential candidate John Dramani Mahama for failing to obey the orders of the court. Now, this was an order that they filed witness statement by close of work last Thursday. Now, Mr. Mahama's legal team, however, did not comply, citing processes that they have filed, including one that is asking the court to halt the hearing of the election petition. Now, remember that Mr. Mahama is in court seeking to set aside the results of the 2020 presidential elections, which he lost to President Akufo-Addo. Well, the court today served notice of its power to apply sanctions allowed by the law should its directive be disobeyed again. We'll bring you details on that shortly, but I want you to listen to this interaction between a member of Mr. Mahama's legal team, Tony Letha, and the justices of the Supreme Court.
In any case, we ask that you file your witness statement. Has it been done?
I beg your pardon?
We ordered
the legal submissions in respect of the preliminary legal objection.
No, my lord.
Those were the orders of the court at the last agenda.
Yes, my lord. Since then, we have filed an application for stay of proceedings, which is scheduled to be heard today. So our understanding
of application for stay of proceedings is that you don't file the processes ordered by the court because you have filed an application for stay of proceedings.
My lord, in fact, the application is actually intended to hold matters. That's our understanding. Pending the... I beg your pardon, my lord.
Then you don't even have to sit.
My lord, I didn't
That is what your understanding of the state of proceedings. Then you don't even have to sit.
And so that is the interaction that happened in court today when the court started. Court correspondent Joseph Akable joins me in the studio. Joseph, there was a point where Mr. Letha made a statement, a comment actually, and the judges demanded that he withdraw. Exactly what did he say?
He had used the word predetermined in relation to what the court was to deal with, that is the review on Thursday. And a member of the panel, Justice Gertrude Tokonu, had concerns. We can listen.
Subsequent to the order, we filed an application for stay of proceedings, and there is a genuine concern that that application would be undermined if we took fresh steps in the matter, and that is the reason why we have not filed it. And particularly when the view is that the review would, if granted, would impact on the kind of witness statements that we would file. unless, of course, the suggestion is that the review is already predetermined, and therefore,
Mr. Leader, don't do that. Don't do that at all.
I'm not.
Do not do that.
I withdraw that.
And so that was what happened. The justices demanded that he withdraw, and he did just that. But then they went on recess, came back to read their ruling, and cited laws empowering them to impose sanctions, and further gave orders to the petitioners. Listen.
Rule 69C4B of the Supreme Court Rule CI 16 as amended by CI 99, which reads, quote, the court may A. Dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time, or B. Hear and determine the petition where the respondent failed to file their answers or the processes regarding their answer within the specified time. Indeed, this position in the procedural rules of the Supreme Court relating to presidential election petition is echoed through the different hierarchies of courts in current case management structure and will not be compromised. Order 32, Rule 7A, Sub-Rule 3 of the High Court Civil Procedure Amendment Rules 2004 CI 87, which governs trials in the High Court, has a similar provision as follows. Where a party has failed to comply with any of the directions given at a case management conference or pre-trial review or both, the judge may make any of the following orders. A. Strike out the action if the non-complying party is a plaintiff. B. Strike out the defense and counterclaim, as the case may be if the non-complying party is a defendant. C. Order any party to pay cost. Or D. Make any the appropriate order. End of quote. The petitioner is again directed to file his witness statement on the matters raised in his petition and other pleadings, and his response to the preliminary objections by close of the day on Wednesday, the 27th of January 2021, failing which this court will proceed to invoke the sanctions imposed on this court by the rules of court. The petition is thus adjourned to Thursday, the 28th of January 2021 for hearing.
So you had the Chief Justice Eninyebua reading the orders of the court after that interaction with the lawyers for the petitioner after they failed to file their witness statement. Joseph Akable is still with me in the studio. Now, Joseph, after proceedings today, the President's legal team had some serious concerns about the conduct of the lawyers for the petitioners regarding their failure to file the witness statement.
He says they are engaged in theatrics. He insists that the Supreme Court...
And this is Frank Davis.
Frank Davis, a member of the legal team. He insists that the Supreme Court is a busy place where serious business is transacted.
The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatrical or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday. Thank you.
So that was Frank Davis there, a member of the President's legal team. Dr. Dominic Ayene, who is a member of President Mohammed's legal team, disagrees and took exception to the use of the word theatrics.
The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Mr. Frank Davis knows that all the applications that we have brought are within the framework of the law. Now, as Mr. Chikata pointed out in court, there was no intention whatsoever on our part to disobey the court. I am sure in all his life as a legal practitioner, Mr. Chikata has never disobeyed any court order. And this is not going to be the first time that he has done that. And I'm sure Frank Davis and his colleagues know very well that applying for stay of proceedings means that if you take any fresh step yourself, you are undermining your own application. And I'm sure if we had been given the opportunity to move our application for stay, and if we had filed any fresh process pursuant to the orders of the court, the same people would have raised objections, saying that we have taken fresh steps, we have waived our right to have the proceedings stayed.
Dr. Dominic Ayene is a member of the NDC's legal team. Let's go into the phone lines now and speak to a private legal practitioner for some education on today's proceedings. Martin Pitt joins us live. Thank you very much, sir, for your time here on Top Story. Now, first of all, is it an unusual practice for lawyers to file, to hold on to certain processes when they have objections or reservations about an aspect of a case that is running?
Oh, yes, it's standard. That much, there will be little disagreement. You see, the day the court made the order that witness statements be filed, okay, yes, that was the order. But subsequently, to the extent that Mr. Mohammed's lawyers filed an application for stay of proceedings, okay, the stay of execution of the order, they were entitled not to file because, as you heard Dr. Ayini stated, if they had filed the fresh processes that would have been filed after the court order would have been used against them. That, in one breath you are protesting, in another breath you've given up. So usually, if you file for stay of proceedings or stay of execution, you would not file any fresh processes that would undermine your own application.
But you had the ruling from the bench today. They thought that once the orders had gone, they simply should have followed through and then come to the court to make their case subsequently.
No, Ernest, that's one. I mean, you can ask any average practitioner. You file an application for stay of proceedings, you won't do anything to undermine it. That's one. I mean, the court is a Supreme Court, so well, at any point they can change the law, but on you ask the average lawyer, if you mount an application for stay and you do any other thing, that shows that you've undermined your own application. Your opponent will use it against you. So nobody does that. That much. I don't think you can check. I mean, sample lawyers, very serious practitioners, they will tell you. Maybe you should ask people like Ace and Kuma and the rest. Very serious, very senior practitioners and very serious at the bar. Nobody will do that. No.
So now on today's case, the Chief Justice in reading the judgment referred to CI 99 and also the rules of court as basis for what they could potentially do if petitioners disobey their orders again. Now, with your experience, your many years of practice in court, is there precedent to this issue? And I'm talking with regards to a court throwing out a case because lawyers are not complying with the orders of a court.
Oh, yes, Ernest, it happens all the time. But Ernest, let me add this small tip. Don't say many years experience. There are 1,000 lawyers who are older than me at the bar. But let's say I have some experience. Yes, what the Chief Justice referred to, that if, the rules of court provide that if you don't obey the orders, the case can be dismissed. Yes, it's true. It's in the law at all levels. There are always those sanctions. Yes.
Even when there's a reasonable cause of action?
Oh, yes. So this, they're good. Now, you see, you've asked a very poignant question. When there's a reasonable cause of action and your case was dismissed because you failed to take a step, then you can apply, so let's say specifically in the High Court, you can apply that the case that has been struck out should be restored. Then it becomes a discretion for the judge to exercise. And then you look at your course of action as one factor, but it cannot be the overriding factor. It's one, because you come to court, you don't have all the time in this world. The court works with rules. So if you're giving time to file processes and you are tardy all the time, one day the judge may just apply the law and strike out the whole case. But then usually you can come back. So let's say in the High Court, if your witness statements and those things are struck out, you can come back and ask for restoration. But usually it's a Herculean task. But in the law, it can be restored.
Are there other options aside throwing out the case? Are there other sanctions, so to speak, that the court can mete out to the lawyers who are not complying with the court's orders, for instance?
Yes, so it depends. So let's say if it were a petitioner who is obeying all the court orders and respondents are not obeying, then the court would go ahead and determine the case because petitioner is ready. But where it is the petitioner who is not ready, then that's when, if you strike out the case of the petitioner, then there is nothing before the court again. Then that's what can bring an end to the case.
Now, originally, the review and other applications filed by the petitioners, including their request for original documents from the first respondent, the Electoral Commission, was scheduled to be heard on Thursday. Now the court has adjourned the hearing, which should have started today, to Thursday. Mr. Peru, just hold the line for me. Joseph Akable is with me in the studio. Did the court give any indication as to when these applications will be heard? Because then it's adjourned the case to Thursday now, the hearing proper.
The point the Chief Justice made in the ruling was to the effect that because its orders had not been complied with, it's not dealing with any matter in terms of the applications until that order was complied with, and it's adjourned proceedings to Thursday. So at this stage, we do not know whether on Thursday it will first deal with the review. There's also a request related to the review to file additional documents to support the arguments in the review as well, and so that is also another issue.
And the EC also has filed some additional.
That particular issue, it may become moot, and I'm sure council can explain that to us, because they were asking for an abridgment of time that what should have been dealt on Thursday should have been dealt with today, and by Thursday, obviously, would be the date that is actually due.
So Mr. Pebu, with all these issues hanging, what do you, perceive would happen in court? What is likely to happen when the court sits on Thursday?
Yeah, so, in matters like this, the Supreme Court has a lot of powers. It's not easy it's not like a prediction game, but this is why it is. You see, once the court has stated today that the petitioners should file their witness statement before any other thing will be looked at, to be candid, it weakens generally the application for review, because then it sends a signal. Well, hey, let me be careful. We don't want to run ahead of the Supreme Court. Let me just stop it here. Let's just say.
Noted, Counsel. Yes.
Yes. So let's end it here. Let Thursday come. You see how it will play out.
Very well. Now, there's also the issue of the timelines. And after proceedings today, Dr. Dominic Ayene made the point. I want us to listen to him briefly, and we'll be back to deal with the issues that he raised in that interview with the media.
Ladies and gentlemen, there is a fetish that is being made of 42 days stipulated by law for this trial. Again, I want to refer you to CI 99, which is the amendment to the Supreme Court rules CI 16. Go and look at Schedule 2 to CI 99. The schedule is very clear that the trial is supposed to take place from January to March. Now just do a bit of computation. January has 31 days. If February is not in a leap year, it has 28 days. And then March has 31 days. That's 90 days for you. Was the lawmaker wrong in stipulating this period for a trial? The view we have taken of this matter is simple. That the trial is the 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis.
So, Mr. Peru, that is Dominic Ayene, the member of the NDC legal team, speaking on the issue of timelines. He believes that the calculation should not be done on a day-by-day basis. As far as you're concerned, from your reading of what the provisions are, how many days have we spent so far, and how many days are left?
Okay, so today is 26th January, right? And the petition was served on the 31st. So that's the day the president was served, and that's the day the issue was also served. If that's correct, you add 1 day in December to today, 26. You get 27 days. So it means that we've done 27, and we're going to 42. So we are left with 27, and then 42. Yeah.
So the calculation you just did is a day-on-day calculation, which is what Dr. Ayena is disputing.
No, it's supposed to be a daily calculation, because if you look at the rules, it says the CI 99, which amends the CI 16, okay? It says the petition should be heard within 42 days. That's in the substantive part of the CI. Yes, I'm aware of that seeming confusion in the schedule. So the CI 99 in the substantive part says that the petition should be heard within 42 days. But when you go to the schedule, it's almost like a diagram showing the step-by-step approach. Then you see the months January to March there. I honestly believe it's some typo, because January to March will not give you 42 days. So in the event of a conflict, you see the 42 days is far clearer than saying the petition should be heard from January to March. You say it. Yes,
and so 42 days. 42 days for Dr. Ayena will mean that every day that the court sits on the case.
No, that's not correct. So you mean certain days. So I'll show you an example. If you go into the Constitution, where the lawmaker wanted to make sure that we should refer to certain days. So some like a constitutional instrument. If you want it to be passed through Parliament, like the CI 127 that we use for the elections and all that. So if you watch the Constitution to say 21 certain days, so they will say certain days. So if the lawmaker wanted to say 42 certain days, Ernest, I'm sure they would easily have inserted the word certain. But once they didn't put in the word certain and said 42 days, it just means the normal 42 days. Yes.
Is that something you think that the court should pronounce on going forward and make it clear to the parties in the case?
Okay. Yes. It helps because, Mr. Mahama has a huge constituency, at least judging by the last election. So if his lawyers see the interpretation differently, it may help so that the court clarifies the meaning of the 42 days. Yes, it may.
Very well, thank you very much. And that's a private legal practitioner, Mr. Martin Pebuda, giving us some education on the proceedings of today as far as the 2020 election petition is concerned. And we'll be bringing you more on the petition today. We'll hear later on Newsnight the former Supreme Court Judge Justice William Atuguba speaking on the election petition. We'll bring you that shortly. Top Story is brought to you by Belacqua Mineral Water and Vodafone. The future is exciting. Gassam, the nation builder. My name is Ernest Manu. Newsnight is up next after these commercials.